transitioning now back into the commission portion of our business. At this time particularly, I'm calling on each commissioner, if you would please, to take your seat back in the front.
Okay, let's please reassemble quickly. I need, if we can, have the commissioners come back up front right away. Okay, we're going to proceed. I think we have almost everybody up front. So, audience, this is the commission working part of the meeting, so we're going to have the commission handle discussion during this part of the meeting. If you have questions or things that you would like to be addressed, the post-it notes or the website are the best way to do it, or certainly feel free to talk to any one of us afterwards. So, commissioners, we have 3 working groups who have been diligent and working very hard to put recommendations and calls for actions together. You have them in writing in front of you. They're going to be on the screen so the audience can see them, and of course are already posted on the website so folks can see them. We're going to take about 10 minutes per working group. We have 3 to report. We're going to follow the normal process where the co-chairs will make the report to you. We'll ask for a motion to adopt the recommendations. Need a second, of course. We'll have discussion among the commission and then move forward to take action on the recommendations. And we'll do that for each of the 3 working groups. So first up is Citizen Law Enforcement Relations, and Commissioner Dan Isom and Commissioner Brittany Packnett are going to handle that.
Thank you, Rich. So here we go. So our Citizen and Law Enforcement Relations group met on Monday. We had a number of folks who were repeat attendees, and this is our formal working group membership, but we had a number of members of the public who have been continuously engaging, and we're very thankful for that. So recently, we just submitted the interim report to the president from his 21st Century Policing Task Force on March the 2nd. And so one of the things that we've been very careful to do is figure out where there is currently alignment between the task force work and the work of the commission, specifically in the Citizen Relationship and Law Enforcement Working Group. And then also to figure out places in the task force report that we should actually look to for an expansion of our efforts. So what other additional things should we prioritize? So what you're seeing in front of you is what current alignment exists. On the left side, you see the 6 central pillars of the 21st Century Policing Task Force. And on the right, or my right rather, you see the current preliminary priorities of the working group. There are some additional places that we discovered from the task force report that are relevant for us to explore in the working group in coming meetings. And so one is the use of technology, Body-worn cameras have been a very hot topic, but also how we are thinking about all kinds of technology currently created and that could be created that collect that kind of audio, visual, biometric data, and also the very important privacy issues that come with that, privacy for law enforcement, privacy for citizens, and how to actually ensure that those protections are written in statute. Actually, number two, clarifying an actual definition of community policing. We heard at, I think, the second meeting, some important academic reflections on what community policing can look like. And in the conversations that the task force had and the witnesses that came forward, we received a great deal of information that can all be found in that report. And so it will be critical for the commission to define what we believe community policing to be based on the input of our community. Number three is officer wellness. Obviously, during some of the very most difficult days of Ferguson, this was something that we needed to discuss. Very long shifts in a dangerous job can lead to difficult decision making, and so want to make sure that we are considering this particular issue. Number four, the task force does talk a great deal about an approach to mass demonstration and prioritizing and training and policies and protocols for mass demonstrations, de-escalation, demilitarization, and so that is detailed in the task force and should be explored through the working group. And number five from the task force, actually looking at not just the prosecution, but the investigation of officer-involved shootings and in-custody deaths. So the task force actually goes so far as to recommend independent and external prosecutors and independent and external investigators in not just officer-involved shootings, but in-custody deaths, right? So stranglings and things like that that don't involve a gun, but are deaths that occur when someone is in the custody of an officer. Additional items that came up during our Monday meeting from members of the community, including special training for de-escalation, not just in mass demonstrations, but also when you are engaging with people from vulnerable communities, in particular people with mental illness. And also developing specific models of cultural training and alternatives to use of force. We've kind of heard very broadly the topic of implicit bias and other elements of cultural sensitivity, but really looking at highly successful national or local models for training that can be implemented, and also looking at how we train people to use alternative ways to control a suspect instead of always opting for use of force.
I would just open it up for questions from the commission. A motion to accept these recommendations from the Police Citizens Community Relations Group, Working Group.
Second? Okay, so so I understand what you're asking for here, Dan and Brittany, is the commission's approval to proceed to explore, to address these areas. There's not a specific, as you said, Brittany, a definition of community policing yet, but this is now in the scope of what you're doing.
Right. These are broad areas that we've identified as priorities, and then we will go back to the working group and flush out the details of these items.
Okay. Questions or discussion from members of the commission? You want to grab a mic, TR, please?
Maybe to, there we go. I appreciate the work that you've done. It looks really solid. Could we amend the motion to conduct a survey of countywide, looking at residents' attitudes towards citizen police, and even include citizen municipal court? We need hard data, and that can really help to guide this. So I would like to propose a favorable amendment to it. Not only we're adopting this thing, but we're agreeing that we will commission a public opinion poll conducted to assess this attitude.
I would be in favor of that amendment. I think it's important that we do, as we do this work, we do have, as we talked about earlier, baseline data on relationships between police and the community and what that looks like across different communities. It's not the same everywhere, but we do need to know where those relationships are very poor and in areas where the relationship is pretty good. So I think that would be a great idea for the commission to have a baseline.
Tracy?
Where is it that we don't know that? Where is it that we don't know that police and community relationships are shot? And where is it that we don't know that they're fine?
Well, I think we know through testimony, and that's important, that people tell their stories about what's happened in their community, and we've heard a lot of that. But I think through a survey, we will be able to define that a little bit better, right? And we will be able to actually see data that says in this particular neighborhood versus this other neighborhood, these relationships need to improve, right?
So I'd like to amend the amendment if I could, and actually open up the opportunity to collect, I would just say more broadly, information. So when I think about the topic of this evening, and I think about the barriers in certain communities to actually collecting what we call hard data, as if the testimonies that we have continued to hear over the last 7 months are not hard data enough, right? Like, so we need to provide opportunity for anecdotal information, quantitative information, and we need to make sure that however we are continuing to collect information, that we are not unduly and even unintentionally restricting certain people from being involved in the process because the way that we set it up is not culturally sensitive. And so I worry about surveys because everybody's not going to fill out a piece of paper because they're distrustful of the body that is putting the piece of paper in front of them already, which is why we're here, right? So I want to make sure that we broaden that word of collecting information enough such that we don't unduly exclude marginalized people.
Oh, that would be it.
Go ahead, TR.
Yeah, that would be pretty much a friendly amendment because we want to not only have the qualitative data, we want to have the quantitative data as well. We want all the information we can get dealing with citizen police and municipal courts as
I
well.
want to come back to Tracy, but as Starsky and I have been discussing this, I think just kind of a process point. We don't want to get to a point where the commission needs to approve every research project. We want to have the flexibility for co-chairs to design that, say this is what we need for the work of our group, and consider the points being made and others that were made here tonight, and then work with the managing director to work it through the bid process and everything that we do in order to get the right research at the right time. So I think the direction of the discussion will be instructive, but I don't think we need to have it as part of the motion. Okay. Tracy? Okay. All right, we have a motion on the floor with regard to these recommendations and a second. All in favor, please say aye. And opposed? No. Okay, so let's move on to municipal courts, and we're going to ask TR and Tracy to please handle this one. Thank you, Dan and Brittany.
So I think what we will attempt to do is note, we had a bit of this conversation in the last session, we continue to roll and commit, so part of what was just considered when you look, I'll say two things. Number one, we note as just a process point, we continue to roll and we will continue to hear from committees. You've not heard a final report from any of the working groups. We'll continue to identify these issues and as they are ready from the co-chairs to bring them forward. The second thing I'll note is in the content of what was just presented, both in the presidential task force report and on the priorities from the work group, there was identified, I think it was the third or fourth element down, the create a legal mechanism for empowered civilian oversight was in the task force, was in the working group report that aligned with the task force, the working group priorities that aligned with the task force report. So that was there, and there's more to kind of continue to get at that. But so I encourage you to assess the slides and their content for that. But I know there's more meat in the work group. There will always be more meat in the work group than there'll be here. But again, this is not the final recommendation. We're moving priorities, and continuing to roll these forward, but appreciating the point. Okay. Commissioner Carr.
I killed it. They'll help you. Go ahead. Okay, we have nothing showing on the screen. There we go. Next slide. There we go. Our working group met last week, and we identified the following preliminary priorities.
Commissioner Carr, if you would hold the mic,
I'm
it
sorry.
may be helpful.
We identified the priorities that are listed on the screen. One is to enforce the current state cap on traffic fine revenue that a municipality may collect. We need to not only enforce the current ones, but clarify reporting requirements, specify enforcement responsibility, include defined traffic revenue. Now, we say that in the context because we know that there's reforms in process in the legislature. So we're saying what currently exists is not adequate, and we want to take the lessons we've learned from the current legislation which doesn't work for any new legislation which comes through. So this is really important for the new legislation that clears the House and the Senate in Jefferson City. Develop alternatives to imprisonment and fines for failure to appear and other minor issues. Provide for an ability to pay hearing before an individual can be detained or otherwise penalized for failure to do so. Create a uniform list of rights and procedural options and consequences across municipalities. We think this is really important because individuals begin to come into a municipal court and they're unfamiliar with the processes, the rules, and the procedures that are following, and we believe they need to be informed uniformly across. We have, 82, 85 municipal courts, depending on how you count. We want a uniform list of the rights and procedural options that are made to individuals as they enter a municipal court. Next slide. Based on the second municipal courts and governing work group session, we issued a number of calls to action that were confirmed. Again, no jail for minor traffic violations and other minor infractions. Address failure to appear charges and suspensions. This is a major issue in some municipal courts because failure to appear results in bench warrants for arrest and people get caught into a round robin. Create a uniform fine schedule with an analysis of ability to pay in advance. Right now, fines can vary from municipality to municipality, and we believe that a uniform fine schedule is something that should be pursued in St. Louis County. Another issue deals with consolidation of violations per traffic stop. Depending on what happens, you may get 1 or 10. We believe there are some we should begin to examine violations per traffic stop so that there is a little less, I guess, what we might call arbitrariness in sometimes citing violations. Reevaluate the point system because the point system has an ability an individual to retain their driver's license, and if they lose a license, they lose the ability to have to maintain their job. So the current point system does need to be reevaluated. And sharing responsibility of community service oversight for municipalities that do not have the capacity to engage in effective community service as an alternative mechanism to pay for fines. Next slide. We've came up with several policy reforms. I'll do this first screen. Tracy will do the remaining. One priority is to enforce state-established cap on traffic fine revenue that a municipality may collect, clarify reporting requirements, and enforce responsibility. And we're referencing Senate Bill number 5. We want to include any unintended consequences and other that may result in any cause of action, and the accountable body is the Missouri legislature. One of the key issues is being able to address this issue of traffic revenue as a major source of revenue for municipalities. We believe that traffic revenue should be there for law enforcement, not for major source of revenue. Tracy?
Good evening, commissioners.
Good evening.
So as you might imagine, with the complexity of municipal courts, as with the complexity of most of the work groups, we have differing of opinions and different ways of looking at things. And so in our last working group session, one of the ways that was suggested that we might approach this work is, rather than trying to come up with the solutions to the problems we face, start from a ground place of asking the question, how might we imagine fair and just governance aimed at restoring community trust through our municipal court system? In other words, if we could imagine, and this is an opportunity for us to imagine, what might that look like? There is a slide that goes with that, and you'll find that these bullet points have question marks on them because these are issues that we know that we need to explore to come to that solution. The first is, what does the independent operation of a judicial court look like? We need a judicial branch of government that operates independently and that is not influenced unduly by connections with the other branches of government. That is a problem that we are facing in our municipalities. Oversight of municipal courts that ensure accountability and transparency. What might that look like? Consolidated courts with full-time staff. The reason for that being, we have municipalities that have part-time staff in judges and in lawyers. We have lawyers who are operating as judges in some municipalities and then go 2 blocks down the street and they're the prosecutor. It unfairly biases the process. At the same time, we understand that we're dealing with municipalities that do not have the financial undergirding to support full-time courts. But what might it look like if consolidating municipal courts, there are some who say abolish them altogether, but even if we didn't do that, consolidating them to larger groups, how might we be able to adequately impact having full-time courts with full-time judges that don't have to moonlight other places? Now, we can look at that and say that has to be done through legislature. We can look at it and say we could try to ask the Supreme Court to intervene. But we've spent all this day talking about learning how to talk to one another and learning how to dialogue. And I would suggest that if we began using those tools, municipality to municipality, that perhaps there's a case that could be made to bring those municipalities voluntarily to the table together. In other words, if you have 5 municipalities paying a part-time judge $20,000 a year, you can make a financial case as to why it makes sense for them to consolidate into one large court system, just the court, not the municipalities in totality, and save money in their individual municipalities and better serve the people that we are addressing. I'm not saying that's the solution, I'm just offering it as a suggestion. I'm a preacher, so I always offer suggestions. Properly funded and staffed courts with judges and lawyers void of competing allegiances. I think I just talked about that. A reevaluation of the point system. Some people think that the point system should be softened so that it is not so easy to lose your license, especially when you are collecting tickets like it's the lottery. Share responsibility of community service oversight for municipalities without capacity and courts that enforce laws without a responsibility for revenue generation. Those are questions that we think we must explore in order to address the overarching question of what does it look like to live in a society that has a just court system. Priority areas, the next slide, I think. Did you do that one? This one. Priority area, develop alternatives to imprisonment and fines for failure to appear and other issues. And the calls to action that we're looking at for that is no jail for minor traffic violations or other minor infractions. Address failure to appear charges. In other words, if you are absent from court, why not just get a warrant and not another ticket plus a warrant? Address failure to appear suspensions. And the accountable bodies, as you can see listed, Missouri Legislature, Missouri Circuit Courts, and the municipalities themselves. Next slide, please. Provide for an ability to pay hearing before any individual can be detained or otherwise penalized for failure to do so. And this would be helped with a uniform fine schedule with an analysis of ability to pay in advance. So when you receive the fine from the court would be mandated to enter into that conversation with you about ability to pay and to have you leave court with a viable, doable way of satisfying your debt. The next area is to create uniform lists of rights and procedural options and consequences across municipalities. The call to action would be to consolidate violations per stop. Oftentimes people now, according to the information we have, you may get stopped for one thing and end up with 6 or 7 tickets. I don't know how we consolidate that, but that is what our work will be about, trying to figure out what works. And soften the point system is there as well. Sorry. So if we create a uniform system of fines, then we know how much everything costs across the board. We cut out some of the additional charges that are being charged in some of our poorer municipalities that we're not seeing in larger municipalities. And I just want to add that is there another slide? I think we're done. Is that the last one? Okay. I just want to add that we are very cognizant that it's going to be a long process in municipal courts because we also have municipalities that are functioning quite well because their tax base is such that they don't have a need to depend upon municipalities for revenue generation. And they don't have a desire to have their system changed. So even as we begin to talk about race, we must talk about the intersectionality of oppression, race overlaying with poverty, which makes for a whole different picture for some of these municipalities. Can we have do we do a motion? Okay. Motion to approve.
We have a motion. Do we have a second? So we have a motion and a second. If we could have some discussion regarding the recommendations, particularly the calls to action from the Municipal Courts and Governance Work Group. Commissioner Hatter.
Yeah, just if you could go back to the first call to action, I just want to make sure I'm okay, go back to that one, where it's talking about enforce the state established cap. I understand, obviously, the 30% that's on the books right now. Can you tell me why we're not suggesting the adoption of something else? You are?
The call to action is to strengthen SB 5, which is what's being considered now, which would decrease that cap, I believe, to 10%, and it's looking like it'll probably end up being somewhere around 15%.
I'm sorry, I just didn't get the SB 5. Thank you.
Mm-hmm.
Other questions from commissioners?
I have a question about court accessibility, because I personally got a notice from a municipality requesting that I appear in court on a Wednesday morning at 10 a.m. I can't do that, and I don't know.
Then you're going to jail. No, I'm just teasing.
Will you bail me out? Do you still have money in the fund?
I think that we addressed that in the conversation that we're going to have about consolidated municipal courts. So if you have a consolidated municipal court, then you hopefully would be able to have the revenue to hire a full-time judge and full-time lawyers, and that would impact the court scheduling.
I wanted to ask a question. Well, I'll defer to other commissioners. Rose, Commissioner Windmiller.
have a question, actually. It's really not about the call to action so much as about input from the insurance industry on the point system. Have you had any? Have we had any input from the insurance industry, and where do we think that's going to stand?
We have not had input. That's why we're saying it's something we want to investigate. We have not had input from the insurance industry about that, but it's an issue that we want to investigate. We know there may be issues with the current point system as it's in place. We also know there may be issues with modifying and changing that point system. So before we move on saying it should be this or changed, we want more and more information. We need some hard data.
Thank you.
I've got a question. And I may have missed it, and maybe we don't know this yet, have not delved into it yet enough, but do we know what kind of things the presiding judge of St. Louis County can change as a matter of like a rules change, and then, or the Supremes, what can they change without having to go through legislation? Have we identified that yet?
The short answer is no. We have lots of lawyers who have stepped up to the plate to be involved in this working group, and those are some of the things that we will be looking at. We found out at the last working group that there's already an entity in place in Missouri. The acronym is OSCA, and it's an entity that exists solely to monitor municipal court systems. They can do a complete evaluation of the municipal court and give recommendations. It appears that they have done that in Chesterfield, they have done that in Wentzville, they have done that in the areas who can afford it or maybe have the connections right now. And so one of the things we're looking at additionally is how to get more funding for that organization that already exists, that we're told they do an excellent job, and to put some teeth behind their recommendations. They don't have enforcement power, but they have the ability to give you an accurate review of the municipal court.
You all have done a great job, and this has been true of all the working groups. That I had a chance to sit in on part of your meeting, but you had municipal officials and court clerks and the law clinics and folks there that had been impacted, and you got input from all of them. There's a cross-cutting theme that I would ask that you all take a look at in the next round, and that is this question of enforceability and accountability. You've got the words here that I think are a great start, because we found out that 30% wasn't being enforced. We know that the Missouri rules and statutes on ability pay and alternatives to fines, community service, are pretty good if they were actually implemented and enforced. So I think a question to pose is, what enforcement mechanism is it? And it relates a little bit to Kevin's question, perhaps. The auditor may have some authority here. The Attorney General may have some authority. Clearly, the circuit court, the presiding judge, under the direction of the Supreme Court, was able to take over the Ferguson Municipal Court. And so we know there is substantial power there. So this cross-cutting theme of enforceability and accountability, I think, would be something to push on. But thank you for your good work.
That's something that we're continuing to examine, because, quite frankly, enforcement is the key. And some of the legislation is very difficult to enforce. It doesn't specify the enforcement body. So those are things that we're looking at. We really want to achieve enforcement.
With thanks to both commissioners, I also want to ask a clarifying question. You have on most of the calls to action pretty clear language about what you want done, the desired outcome. Related to failure to appear charges and failure to appear suspensions, the language is a bit more neutral. You ask that they be addressed, not that they be eliminated, not that they be consolidated. So I just want to give some opportunity to be thoughtful about what is the verb, what would be the desired outcome related to failure to appear charges and suspensions under that specific call to action.
So we left it vague for this particular time because, as I mentioned at the beginning, we have multiplicity of personalities and interests that are in our group. And so in an effort to wait until we have that conversation fully and can adequately represent what the work group's desire is, we didn't go any further. We have some things on the table. Some of them would be eliminating all of the outstanding warrants of that as a good faith measure to build trust in the community and starting all over again, making failure to appear tickets go away. And if you don't show up for court, then you get a warrant, but you're not penalized twice. But all of those are still in the conversation realm. There is a House Bill 962 that's going through the process right now that deals with fair and equitable municipal courts. And we're also looking at that to see what parts we can support and what parts we might be able to suggest be strengthened.
One thing also is that failure to appear warrants are utilized differently across the municipalities in St. Louis County. So it would be probably, at this stage, inappropriate to make a blanket statement once that you so such a diverse application of this particular process, and we want to find out exactly what's being done in all of these courts. That's why we dealt with addressing it.
Good deal. Thank you very much. Are there questions from any of the commissioners regarding the calls to action and recommendations from the Municipal Courts and Governance Working Group?
Can I just make one more comment for the record?
Absolutely.
The publicity and the targeting for municipal courts has been on traffic. But the issue can't be just to fix the traffic issue, because there is a deformed entity. There's a deformity in the way we're operating our municipal courts. And so if we just address the traffic entity, then the revenue gouging will show up somewhere else. And the community is very aware of that and very determined that we fix this problem from its root and not just pull off the visible leaves. We don't want to then see people being sanctioned for ordinances on their homes or their property to make up for the revenue that they can't get from traffic tickets.
That's a great point. With that said, we do have a motion and a second on the recommendations on the calls to action from the Municipal Courts and Governance Working Group. If there's no more discussion, all those in favor, please notify by saying aye. Aye. Opposed, nay. Any abstentions? The motion carries. Thank you very much, Commissioners Carr, Commissioners Blackman, for your leadership in this area. We'll now have an update from the Child Wellbeing and Educational Equity Working Group, led by co-chairs Becky James Hatter and Dr. Grayling Tobias.
Good afternoon, good evening, Commissioners, and thank you very much for giving us this time. Our work group has met 2 times. Our meetings are scheduled through summer, and we've had a really great showing of our community in each one of our meetings. So I think the priorities that we're going to present tonight are not only a reflection of the work group itself, but clearly the community that's been involved in these meetings. We are focused tonight in our recommendations really on the transfer law, and Senate Bill 1 and in House Bill 42 is where we are tonight in our recommendations. But before Dr. Tobias and I go through these recommendations, I do want to tell you that there is an enormous amount of work in process on child well-being, reminding everyone that that is 0 to 25, and it is ranging from mental health to food to physical health to how social services are working together, and the list goes on and on. So that body of work is in play as we speak. But for tonight, if we could just recognize the members of the group that are made up of certainly leaders in education, both in the as superintendents. We certainly have leaders in the university area that are in the business of education. We are grateful to have individuals in the mental health field, leaders in this country working on these issues. And so we have just been absolutely pleased with the level level of work that our work group is putting forward at this time. So going right to our priority areas. If we could skip through and go straight to the priority areas. Okay, thank you. The first one that I would like to speak to is the issue of ensuring accountability for students. And I would just like to remind everyone that our job in this work group is to be about kids and to make sure that our kids are getting what they need. So the very first thing that we looked at, there were actually 4 big issues that our work group and the community that was in the room pointed out that they really wanted us to speak to. And the first one is to remind everyone that the idea of district accreditation and school accreditation. And so we recognize both of those, that districts need to be accredited or unaccredited, but schools within those districts also must be accredited or unaccredited. So in the case where a school district is unaccredited, but it has schools within the district that are accredited, our group and the community that was participating was in favor of first a child being able to stay within their district but have the choice to move to an accredited school. So that is the first recommendation or the first call to action. The second one is clearly to say accept students. If a student is moving from one school district, an unaccredited school district, to a receiving school district, there is language that says a receiving school district could deny a child's entry into that receiving school district based on behavioral issues that they could not be kicked out of their existing school district for. And so we were not in favor. No student shall be denied the ability to transfer or excluded from a receiving school district when they can still stay in the home school district. And the only way a receiving school district should be able to deem that child ineligible is if it meets the safe standards, the safe schools violation, which is the extreme issues that would also make them ineligible to go to their home school. And then the last one was mandate accountability to the receiving school districts. So in the laws that are being considered right now under the transfer law, if a student wants to leave a unaccredited school district and go to a receiving school district, and the receiving school district has the ability to set the fee, as it is right now, then if they only charge them 70% of the fee they set, the receiving school district is not required to be accountable up to 5 years. We think the issue is accountability. So either the home district is accountable or the receiving school district is accountable, but we accept no language that says you get the funds and the child, but you're not accountable for either one. And there is a layer that says if it's 90%, then we're not accountable for 1 year. I do not think that our work group would agree with anything that would say that the adults should not be accountable for children. And I think the last recommendation or last call to action that we would have is that we adopt the VIC fee, the calculation of $7,200 as the maximum rate in the transfer. And I'm going to turn it over to Dr. Tobias to do the last one, and then of course we'll take questions.
Thank you. The next priority area is to strengthen the capacity of school districts to implement policy. And the call to action is to ensure that the members of the assistance teams are qualified based on their past performance in failing districts with similar circumstances, and omit or change language to may consider the recommendations of the assistance teams. And the accountable body is the Missouri legislature. Now the language says something like strictly adhere to or must. And so the issue is, or the question is, are the members of the assistance team successful in working with either underperforming or unaccredited or failing school districts? And I think it's important for those members of the assistance teams to have a proven track record of working with turnaround situations. In the past, and typically the assistance teams are comprised of individuals from all over the state of Missouri. There could be rural participants, urban and suburban. So we want to make sure that the members of the assistance teams have a proven track record in turning around school districts. So with that, we ask for a motion to approve the calls for action for the Child Wellbeing and Educational Equity Work Group.
Is there a motion to approve the child well-being and equity calls to action? Have a move and a second. Any questions or discussion? Commissioner Packnett.
Oh, great. So 2 questions. One is about the exception for children who would be disqualified from attending if they had violated the Safe Schools Act. Has the working group at all explored if they're, so from my understanding, part of the Safe Schools Act actually requires the school board to set the policies of discipline. And my worry is that the disproportionate nature of discipline that we see across our community based on race and gender would actually then be extended to this place if we don't consider something else. So I'm wondering if the working group has heard any kind of expert testimony on how the Safe Schools Act has actually affected our community and if we are seeing those same disproportionate numbers locally.
Someone said the short answer. The short answer is yes. We are seeing disproportionate application of discipline all over the county. In fact, I think Sunday, for example, there was a huge article which spoke to that point.
Right. So then I'm wondering then, given the, I guess I was technically a call to action, right? So it says only students who have committed a safe schools violation will be ineligible for transfer. If we know that certain children are disproportionately being seen as violating that act, then aren't we extending the disproportionate nature of those violations to children who will then be ineligible to transfer?
Well, I think I see it this way. Districts would try to exclude certain students who have multiple disciplinary infractions, maybe not Safe Schools Act violations. And so in an effort to make it equitable, if a child is not going to be permitted to a school in the current school district, they should not be permitted to attend a school in the transfer school district, in another school district. And so from,
Go ahead, sorry.
I was going to say the issue for me is what we call the repeat offender. But for the major Safe Schools Act violations, those are incidents of violent behavior, and those students would be excluded no matter where they attend school. For example, some of those violations would be like first or second degree murder. I mean, for first or second degree murder, or first or second degree burglary, or many violent offenses like that.
I guess maybe I'm asking a really technical question, so it can be maybe up for consideration in different working group conversations, because I'm thinking of that portion of the Safe Schools Act that says there is some discretion for what is considered a violation by the school board. And so I'm not talking about the things that are kind of mandated and explicitly stated in the act. I'm talking about those policies that are set up by individual school boards that we know affect certain children disproportionately.
Absolutely, that's a totally different issue. There is no exception with a violation of the Safe Schools Act violation. But to your point, yes, there should be some discussion in our work group about those local mandated. I think it's more of an implementation and an enforcement and a fair and equitable application of the local school board mandated enforcement of the discipline policy. That's what I understand your question to be, not the Safe Schools Act violation.
I think Dr. Tobias and Brittany, Commissioner Packnett, just to verify what we just heard, is that the work group did not undertake the question about safe schools violation as it related to the ability for the district to set those. And so raising that up, I think back to what Dr. Tobias, we will absolutely take that back. But at this moment, the legislation is moving pretty fast. And so our work group wanted to make sure that we weighed in and careful to shine the light on the things that we felt like were the issues that we really needed to focus on. So,
thank you.
I just have a question. I don't understand. I know that you want to stop it, but what does that exactly mean, postponed accountability? I don't know what you're stopping.
So if a student is in an unaccredited school district and they want to go to another accredited school district, the school district, the receiving school district, sets its own fee at this point. They can say, we are not going to charge you 100%, we're going to charge you 70%. And if we charge you 70%, we are not accountable for that child's performance for 5 years. Yeah, like hold that. So a kid could be in first grade and it's 5 years, or seventh grade is 5 years, or a freshman. And so this is what we're saying, is that you cannot accept students, children, and the money and say we can't be held accountable. Just, so we see no language, not even the 90% that's proposed. We'll charge you 90% of our fee and we're not accountable for a year. We don't see that you can ever, as a school district and as an adult, as long as we have these accountabilities, when the children come, we have to be accountable.
I want to commend you for...
Just in terms of accountability, to drive that point home, that means the students' test scores don't count for that particular district.
I want to commend you for tackling this. I think one of the definitions of unflinching in our charge is to be and speak to gaps where no one else is really calling out this issue. And as far as I know, this provision that we object to was in the bill last year that passed and was vetoed. It is in this year's bill, and I don't see a hue and cry of people saying what you're saying tonight, which is, wait a minute, you know, what do you mean, these kids aren't important? I mean, your focus on the child and the accountability for the education of that child is spot on, and I think we need to put an exclamation point on this in Jefferson City and say you need to fix this in this bill.
Well, it's ironic that we know how to count test scores, but we don't know how to count kids. So, thank you, Co-Chair.
Commissioner Blackburn.
It's a conspiracy.
It
Now
is
you're
not
gonna
a
break it.
conspiracy, Commissioner Blackburn.
I'm still going to say it. I'm on this imagining what's possible, and I'm also on this intersectionality of oppression. So I'm curious as to whether or not this work group has given any thought to the vast discrepancy economically in our neighborhoods that impact our school districts, and whether or not there's been any thought in my pie in the sky way, if we really care about all children, and a lot of the money for the school districts is coming out of property values, which are not the same across the board. Has there been any conversation about suggesting a consolidated pool of money for education where every child gets the same amount of money allocated no matter where they live?
Commissioner, I can assure you that there are robust conversations about the way public school is funded on the property tax issue. And to that end, we have had conversations, but we are in touch with lining up experts around the country that understand this to advise us. So it is very much on the table, and we have some of those experts here in St. Louis that really understand public education funding and how do you navigate much the same issues that you're navigating on the municipal level. What would that look like? And then how do we really get it done? So the whole structure of financing public education is very much there.
Thank you.
Good. We're going to close discussion here and ask the commission. We do have a motion and a second on the floor related to advancing the calls to action related to the transfer bills that are currently moving in the Missouri Assembly from the Child Wellbeing and Economic Equity and Educational Equity Work Group. All those in favor of the recommendations and motion as stated, please notify by saying aye. Aye. Opposed, nay. Abstentions? Motion carries. So we thank Commissioners James Hatter and Tobias for your leadership and guidance in this area, particularly as noted before in this swiftly moving conversation, so we have occasion to weigh in to the discussions. This closes out the portion for the working group updates. We did skip one item on the agenda, which is our financial update from our managing director. We will go over that quickly. We thank her for her leadership and guidance and great stewardship, and now give attention to a financial update from our managing director, Bethany Johnson-Javois.
Please, for commissioners, you have information in your packet, and for the audience, you can go to the stlpositivechange.org website to access information, and Monique Thomas is getting ready to pull it up as well. In the spirit of transparency, which we committed to, we're going to scroll down. We'll scroll down to show the budget. In our revenue category, the state of Missouri to date has given us $200,000. You can see the funding sources with $975,000 that is budgeted, and that funding is on its way from the state of Missouri. That we're happy to report that. So the total is $975 for the revenue coming from the state of Missouri. We're grateful for all of the partners that have given us private support that totals $150,000. And we have estimated in-kind support from our community, from businesses, from organizations that have donated time, space, energy, and other things that we've needed to the tune of over $284,000, and that's probably on the low side. So we want to thank them for that, which brings total revenue to $634,000. On the expense side, if you scroll down a bit, You can see how we've itemized our budget. Our expenses right now are coming in 4 categories: independent contractors, professional fees, operations, and the bulk of the funding that we are receiving is going toward the engagement. All of this, tonight's meeting, the lights, the rental, everything that you're seeing, the court reporting, and all of that is funded up under commission meetings, community engagement, and independent contractors. The subtotal there is over $162,000. So our total expenses are a little over $446,000, and we have $187,000 remaining, again, anticipating additional funding to come in. I just want to take a note to say I want to thank United Way on behalf of the commission for you serving as fiscal agent. I think Danielle, just left, but we still want to thank United Way for their support, serving as fiscal agent, and for all their support ongoing. I think at this time, if commissioners would, we should approve our budget.
So in this end, we've had, you probably didn't hear it because I was moving this microphone around, but Commissioners, was it Commissioner Watson? Oh, Commissioners Blackman and James Hatter moved acceptance of this financial update related to the budget. Is there any further discussion? Hearing none, and with thanks to the staff for their great stewardship, guidance, and this update, just call the question for acceptance of the financial report. All those in favor notify by saying aye. Opposed, nay. Abstentions? Thank you very much. At this point, we are prepared to close our meeting. We want to just say thank you to all of you for being here and sticking in through to the end with us. I think we were on our schedule, on our detailed schedule, scheduled to close the meeting at 8:53. We apologize. It is currently 8:58. We thank you for sticking in with us and your care for these matters that are so important to us. We will invite you to stand if you would. We recognize that this is difficult work. We begin this work always with an invocation. We believe that in as many models and as many approaches and as many challenges that we have and the things that we have to explore, these are good. But one common grounding that Rich and I have that we brought into this work is a grounding of faith and centering on a power that we believe it will be necessary in this work as well. Honoring that this is different for different people, we invite you at the close of these meetings to just center in on whatever that power is for you, whether it is a faith in God, whether it is a faith in the capacity to bring the best of our community's energies. We tend to close in a bit of silence for centering that we may energize ourselves for the work ahead. So we invite you to a period of silence and centering. In the spirit of gratitude and with hope for equity and reconciliation for our region, we give you thanks and bid you good night.